Okay, let's unpack this. We are diving deep into one of the most pressing yet sort of silent revolutions happening right now, generative AI making its way into the courtroom.
Yeah, it's less about robots judging cases and more about tools like ChatGPT,
Yeah.
Google Bard, fundamentally changing how legal work gets done all over the world, really.
And it seems like a massive game of catch-up for the courts.
It really is. We're looking at a bunch of sources today comparing how common law courts, places like Australia, New Zealand, Singapore, the US, the UK, are trying to grapple with Gen AI.
So what's the mission for this deep dive?
We're trying to distill that core tension. How do you balance the huge efficiency gains technology offers against the absolute need for justice to be and appear fair and reliable?
And right off the bat, it's clear there's no single answer, no global playbook. You see this fundamental split in just how courts even think about AI.
Absolutely. That's the core conflict. Is AI just another tool, maybe a fancy one, that lawyers need to use competently, following existing ethics? Or is it something totally new, a unique risk that demands its own specific rules?
And Singapore seems to be leaning towards it's a tool.
Kind of, yeah. More permissive.
Yep.
Trusting the lawyers, basically, to figure it out using the rules they already have.
But then you swing over to, say, New South Wales in Australia.
And it's completely different. They're saying, hold on, this is a specific danger we need to put fences around. Much more prohibitive.
Right, demanding new, strict rules.
Exactly. Rules specifically designed to protect evidence, protect confidentiality. And that split trust the professional versus regulate the tech. That's really the source of all the friction we're going to talk about.
Okay, so if we're talking friction and risk, we have to start with the big one, the AI legal nightmare, hallucination. For anyone listening who isn't, deep in AI jargon, what exactly is hallucination when we talk about these large language models, these LLMs?
Hallucination is basically when the AI confidently spits out information that sounds totally plausible, authoritative, maybe even perfectly formatted, but it's just wrong, made up.
Wow. Okay.
And it's not really a bug in the system. It's sort of inherent in how these predictive models work. They're designed to generate likely sequences of words, not necessarily true statements.
And in law, that's uniquely dangerous, right? Because it looks so professional.
Insidious is the word often used. You get these perfectly coherent paragraphs citing non-existent cases, inventing bits of legislation, or referencing legal precedents that just don't exist. Pure fiction.
Which just completely undermines a lawyer's most basic job,
Yeah.
citing actual verifiable authorities.
Precisely.
Yeah.
And look, this isn't just theory. We've seen lawyers face serious consequences. There was that really high-profile case in New York, Mata v. Avianca.
Oh, I remember reading about that one.
Yeah, attorneys got sanctioned. Big embarrassment because they filed briefs citing completely fake judicial opinions, even fake quotes, all generated by ChatGPT.
Imagine the professional fallout from that. Your reputation, the client's case.
Everything's on the line because you trusted something that looked real but wasn't, and you didn't catch it. It's terrifying, frankly.
So the output looks right, tricking the lawyer.
It tricks them into assuming it's accurate, and that leads directly to the courts putting up these really strong guardrails, like the anti-AI verification rule.
Okay, this is fascinating. Why are the courts saying you can't ask the AI to check its own homework? Why can't the machine verify itself?
Well, because these AI systems, especially the big public ones, they don't actually reason or know things in the way a human does. And crucially, they don't have live, verified access to official legal databases.
Okay.
They work by predicting what words should come next based on all the text they were trained on. So if you ask an AI to check a fake case, it just gave you.
It doesn't go and search Westlaw or LexisNexis.
No, it'll likely just generate another plausible-sounding response, probably confirming the fake case or maybe slightly modifying the fake details. It can't step outside its own generated reality.
So you get stuck in this loop of plausible nonsense, like asking a talented liar to vouch for their own story.
That's a great way to put it. It's a closed, circular system. The courts see that, and so they mandate human verification. Using the old-fashioned reliable sources, the responsibility stays firmly with the lawyer.
Got it. So that human check is non-negotiable. Which brings us to another key dividing line we see, especially in Australia. The difference between using AI for evidence versus using it for argument.
Yes, that's a really critical distinction. There's a bright line there.
So AI is basically forbidden for evidence.
Pretty much, yeah. When you're talking about affidavits, witness statements, character references, documents where someone is swearing to the truth of their own knowledge or observations, AI is generally a no-go.
Why that strict prohibition?
It comes down to authenticity. The whole point of that kind of evidence is that it's the deponent's own words, own memory, if AI is drafting it or even tweaking it.
It undermines the whole idea that this person is testifying to their truth. You can't effectively cross-examine an AI.
Exactly. And New South Wales, again, is probably the strictest here. Their rules, practice note SC Gen 23, don't just ban using AI to create evidence. They explicitly ban using it to alter, embellish, strengthen, or dilute what a witness has said.
Wow, so even minor edits using AI are out for witness statements there.
Total ban on AI touching the core substance of human testimony.
Yeah.
It's about preserving that direct link between the witness and their words.
And NSW has that unique disclosure rule too, right? Related to evidence.
Yes, it's quite clever. Affidavits and witness statements there actually have to include a statement saying generative AI was not used to create the content.
The disclosure of absence, that really hammers the point home.
It signals very clearly to the court. It's a
Yeah.
purely human testimony.
Okay, but then you flip the coin. When it comes to legal arguments, submissions, summaries, that sort of thing, the rules seem to loosen up quite a bit.
They do, because the dynamic changes. For advocacy documents, the lawyer is the author, the strategist. They're synthesizing information and presenting a case.
And they're professionally responsible for checking everything anyway.
Exactly. So using AI to help draft written submissions, create chronologies, summarize arguments, even indexing that's generally seen as acceptable. It's a productivity tool.
As long as.
As long as a lawyer meticulously verifies every single fact, every citation, every legal reference, the AI can help generate the text. But the lawyer owns the content and its accuracy. It's about efficiency in argument, not replacing human testimony.
Okay, that distinction makes sense. Now let's pivot slightly. We've talked accuracy, and now let's talk confidentiality. This seems like a whole different kind of risk compared to, say, using a secure internal database at a law firm.
It absolutely is.
Yeah.
Traditional legal tech risks were mostly about access control. Who can get into our secure system? Is it firewalled properly?
Right, keeping unauthorized people out.
But with public generative AI platforms, the risk shifts. It becomes a data persistence problem.
Data persistence. Tell us more about what that means in practice.
Okay, so imagine a lawyer is using a free public AI tool. They paste in some text from a confidential client email, maybe asking the AI to summarize it or rephrase it.
Uh-oh.
Yeah. That input, that confidential text, might get automatically sucked up by the AI platform and used to train the model further. It becomes part of the AI's vast knowledge base.
And once it's in there,
It's basically in there potentially forever. You can't reliably delete it. And bits of that confidential input could, theoretically, surface later in a response the AI gives to a totally different user, asking a completely unrelated question anywhere in the world.
that's horrifying. So privileged client information, sensitive settlement details, stuff under a suppression order.
Could inadvertently leak out just because someone used a public AI tool for drafting or research. It's a massive potential breach of confidentiality and privilege happening just through normal use.
So that's why some jurisdictions are putting up really specific barriers around confidential info.
Yeah, exactly. NSW, for example, explicitly forbids putting information into Gen AI if it's subject to non-publication orders, or if it falls under the implied Harmon undertaking.
Can you quickly remind us what the Harmon undertaking is?
Sure. It's a legal principle that says documents you get from the other side during the discovery process in a court case can only be used for that specific case.
Yeah.
You can't just take those documents and use them for some other purpose, like starting a new lawsuit or leaking them to the press.
Okay.
So if you feed documents obtained under discovery into a public AI model, you've potentially just broadcast them outside the permitted scope of that litigation. Big breach.
So the rule is essentially don't put sensitive stuff into public AI unless you're absolutely sure the platform won't use it for training and keeps it locked down.
That's the gist. The data has to stay in a controlled environment and not feed the main AI model.
But there might be a safer path forward with specific types of tools.
Yes, and the UK judicial guidance points this way. They mention that secure enterprise-level AI tools, things like Microsoft's Copilot chat, when accessed through secure judicial accounts, for instance, were different.
How so?
Because those platforms are often designed with privacy guarantees. They explicitly state that user inputs within that secure environment are not used to train the public models and remain private. So it suggests the problem isn't AI itself, but the security model of the specific tool you're using, public versus private, essentially.
Okay, let's zoom out again. Looking at the whole regulatory picture, the most striking thing might be how differently everyone handles disclosure. Do you have to tell the court you used AI?
Yeah, the requirements are all over the map. It really shows the lack of global agreement. You've got Singapore at one
The
end.
permissive approach again.
Right. They
Mm.
basically say, look, you don't need to preemptively tell us you used AI unless we specifically ask.
Yeah.
They treat it like using Microsoft Word or any other standard tool. No special disclosure needed by default.
Okay, then where does somewhere like Victoria, Australia fit in?
Victoria is more in the middle. And interestingly, they focus on self-represented litigants, people without lawyers. They encourage, strongly encourage, these individuals to disclose if they used AI.
Why encourage them specifically?
It's not about catching them out. It's about giving the judge context. If the judge knows a document was drafted with AI assistance by someone without legal training, they can better understand where potential errors might come from or assess the person's actual level of legal understanding. It's helpful information for the court.
That makes sense. And then at the other extreme.
You have the mandatory camp. Many U.S. federal judges now have standing orders requiring lawyers to certify they've verified everything, sometimes specifically calling out AI-generated citations. And as we mentioned, NSW requires that disclosure about not using AI for evidence. So from no disclosure needed to encourage to mandatory verification and disclosure, it's fragmented.
Which makes the New Zealand approach really stand out, doesn't it?
It really does. They seem to have recognized that one size just won't fit all. So instead of one set of guidelines, they created 3 separate sets.
3 sets. For whom?
One set specifically for judges and court staff, another for lawyers, and a third tailored for non-lawyers or self-represented litigants.
Why break it down like that? What's the benefit?
It's incredibly pragmatic. It recognizes that the risks, the capabilities, and the responsibilities are different for each group. Judges have unique concerns about judicial independence and access to secure tools. Lawyers have professional duties and verification skills.
And non-lawyers.
Non-lawyers often lack the legal training to spot hallucinations or understand things like privilege. So you can't hold them to the exact same standard as a seasoned lawyer using the tool. Tailoring the guidance makes the rules more effective and fairer for everyone involved.
That seems really thoughtful, focusing on the user, not just the tech. But despite all this variation, permissive, prohibitive, tailored, is there any common ground, anything all these courts agree on?
Absolutely. One fundamental principle shines through everywhere. Using AI, no matter the tool or the jurisdiction, does not change the user's underlying responsibilities.
The buck still stops with the human.
100%. The lawyer or the litigant remains fully accountable for the accuracy, the relevance, the completeness, the truthfulness of whatever they file with the court. You can't blame the AI if you submit something faulty. That's not an excuse. The human must verify.
So, summarizing this complex picture, we've got a fragmented landscape, definitely, but it's held together by these core concerns: accuracy, confidentiality, and ultimate human accountability.
Yeah, and the main split seems to be between the very prescriptive, almost fearful approach like NSW and the more principles-based, trust the professional approach like Singapore.
With others like Victoria and New Zealand trying to find that tricky middle path.
And importantly, many of these guidelines explicitly say they'll be reviewed periodically. They know the tech is evolving incredibly fast.
Which leads perfectly into our final thought for you, the listener, to mull over. Courts are already building in adaptability, right? They expect things to change. So as the technology matures, maybe we get secure enterprise AI tools with built-in verified access to legal databases. Maybe verification tools get way better. Could we see a shift? Will those hardline categorical bans on AI for things like evidence start to soften? Could we move towards more nuanced risk-based regulation, assuming the verification problem gets, well, substantially solved?
That's the multi-billion-dollar question, isn't it? Where does this all land in 5-10 years?
A huge legal and tech quandary, something to definitely keep an eye on. We'll leave you with that thought.